And I'm going to talk about the state's conflict of interest law and how that applies to us as public employees. I have a slide deck I'm going to display shortly. Just a few ground rules as we get started. The presentation is going to be about 90 minutes. I'll do my best to conserve our time as best I can. If anybody wants a copy of the slide deck, on the very first page that I'm going to display will have my contact information, which includes my direct phone line and also my email address. And that's also valuable. Okay, Jim, you've made me the host, so now I've got responsibility to admit everyone. So I'll just.
I meant to make you the co-host, so let me go back to that.
That's all right. So I love this new technology, right? So in any event, as we go through the presentation, you may have questions. And if you do, don't be afraid to ask the questions. I think sometimes it helps the information resonate better with everyone when we can have any type of discussion. Just a couple of ground rules. Number one, I'm not a lawyer. So as I explain the law, just understand I'm not giving anyone legal advice about what is required to comply with the conflict of interest law. Also, as to questions, keep them hypothetical. In other words, don't tell me you violated the law or somebody else violated the law, and we'll be fine. And I'll do my best to provide a general explanation. I would ask that you mute your audio as we go through the presentation so that we don't get any extraneous background noise coming through. But then if you do have a question, just unmute and just call out. There's also a chat feature. I don't know if it's enabled. Let me see. Yeah, I've enabled the chat feature, and I'll if you want to send something to me or to everyone, you can use the chat feature, and I'll monitor that, and maybe Jim can help monitor that as well, and we'll take any questions that you have. Okay, so with that, I'm going to switch over from the Brady Bunch view to a screen sharing view. And you'll see my slide deck. Let me get that set up the way I want. There it is. And you can grab the video screens and move them over to either side of the screen so you get maximum exposure with the slide deck. And so having said that, let us proceed. So in any event, again, my name is David Giannotti, and I'm with the State Ethics Commission. I'm the chief of the Public Education and Communications Division, and we're going to talk about the state's conflict of interest law and how that applies to you, or to all of us who work in government. Now, if you have any questions, as I said, keep your microphone muted, and then unmute yourself and call out, or use the chat feature. Now, I am not able to see the chat feature, so Jim, I would rely on you if you can keep the chat window open, and then let me know if we have any questions, and I'll do my best. When I stop sharing my slide, then we'll look at the chat feature again and handle any questions. I'm going to stop my video for a second because I tend to get animated. Well, for the presentation, there we go. Now I'm much more comfortable. So when I start waving my arms, it won't constitute a distraction for everyone. You can choose to either mute your video or leave it on at your discretion, and we'll proceed. So if you have any questions, if you want to go offline for any reason, here's my contact information, and feel free to reach out after the presentation. And we'll do our best to get to the information you need. So we're public employees. We work for the town, I work for the state, we're all public employees. And the conflict of interest law is designed to maintain confidence in government, confidence in the work that we all do as public employees. And so what it strives to do is to ensure that public employees are always serving the public interest, that in all of their actions, decision makings, they're considering matters on the merits, they're following all the rules. And so what the law does is it imposes restrictions on you and on all public employees. If you're performing your duties and what you will do will affect some component of your private life, that's a conflict of interest. And the conflict of interest law targets conflicts of interest. And a conflict of interest occurs whenever your public responsibilities and private interests overlap. Whenever a matter you're poised to handle as a town employee affects some component of your private life. And when you're talking about your day-to-day activities, conflicts of interest basically fall into one of two buckets: financial interest conflicts and everything else. As to financial interest conflicts, they fall under the section of the conflict law we refer to as the nepotism section, nepotism and self-dealing. And the law says that if you encounter a situation as a town employee where your financial interests are going to be affected, or the financial interests of certain family members, you're out. You are disqualified as a matter of law from performing your duties, even though what you are handling is part of your duties. If financial interests are affected, you have to stay out of those matters. The terms that we use at the Ethics Commission to reflect this are abstain and recuse. Whenever you hear those terms, that means, at least in our world, they may have a different meaning in a different context, but in our world, it means that the public employee is stepping back from the matter because financial interests are affected. Now, there are workarounds. When I say the nepotism section, understand that the whole reason this stuff is important is because the conflict of interest law can get fairly complicated in certain areas. And the whole point of what we're doing here is to get you to understand when a red flag should go up. If a red flag goes up, then we want you to get advice about what to do, how to comply with the law. We want to drive all questions about the conflict law to the Ethics Commission. But you can also go to the town council, provided that Jim or the selectmen have a process for allowing that. But the Ethics Commission provides free confidential legal advice to all public employees who are subject to the law. If a question comes up, if a conflict of interest comes up, call us. Call us, right? Whatever. That's what we want to happen here. So the nepotism section is just one of 29 sections of the law. But it's an important one for financial interest conflicts. It's a very significant restriction under the conflict law. The second bucket that we're going to talk about deals with all other types of conflicts. When you're talking about your day-to-day work activities, there's the nepotism section, but then the second bucket deals with all other types of conflicts that don't feature a financial interest component. Those are what we refer to as appearances of conflict of interest. And they fall under the section of the law we refer to as the Code of Conduct section. Now, an appearance of a conflict is not an actual conflict. It's just a circumstance. But while we're serving the public interest, if a situation comes up where you're poised to do your job, but some component of your private life is going to be affected, but there's no financial interest impact, those are the situations that create appearances of conflict. Because the public, looking at how the public's business is being conducted, might become concerned about whether you as a public employee are serving the public interest or not. Because when you're talking about conflicts of interest, the analysis is never internal. It's not about whether you think you could be improperly influenced because a vendor bought you lunch, for example, or somebody provided you with a gift to show appreciation. Conflict of interest analysis is always outside in. It's always about what will the public think if they were to learn of these circumstances, where I am performing my duties and I am required to serve the public interest, but yet this issue will affect some component of my private life. And so under the Code of Conduct section, these appearances of conflict of interest, the law doesn't require us to stay out of the matters like it does under the nepotism section. We can, if we so choose, but the law allows us to continue to perform our duties, provided that we first put the cards on the table, that we first file a written disclosure with the boss that we have that conflict of interest. And we're going to talk about that in a little bit more detail. If situations resonate, make sure that you understand that the conflict of interest law might apply and that you would do well to contact the Ethics Commission for free confidential legal advice. Now, Public responsibilities, that's the job. You understand that. Private interests, what are private interests that might rise to the level of a conflict of interest? And understand that a private interest for conflict law purposes is a tangible relationship. It's not a policy bias. You know, it'd be you're pro-tax, you're pro-business, you're pro-school, you're pro-senior, whatever. Those are internal biases we all bring to the table when we do anything. Those kinds of biases do not rise to the level of a conflict of interest. When you're talking about a conflict of interest in an outside private interest, those are our biases that are tangible. Who we are, where we live, who our friends are, who our family members are, what outside business interests we might have, what outside organizations we might affiliate with, what church we might affiliate with. Really, it's any component of your life off the public job could be an outside interest for conflict of interest law purposes. And the whole point is, if a circumstance presents itself, red flags should go up, and then call our office. All right, so we have this ethics commission. It's a state agency. It's a tiny state agency, but it has a lot of power in that it's a law enforcement agency. The whole reason we need to know about conflicts of interest is not only so that we can maintain integrity in the work we do as public employees, but because the Ethics Commission can enforce the provisions of the conflict of interest law. The Ethics Commission can impose civil penalties of up to $10,000 for any significant violation of the conflict of interest law. And we want to avoid any circumstances such as that. So that's why we want to talk about the law, so that you understand when the red flag should go up. But we have this 5-member commission. It's a state agency, an independent state agency. The members of the commission are appointed by the governor, the attorney general, and the secretary of the state. Now, I'm a member of the commission staff as a division chief. I report to the commission's executive director, and we all report to the 5-member commission. And the job of the commission is to provide advice, education, and enforcement of the conflict law, which is cited as Mass General Laws, Chapter 268A. And there's also a second statute that's not relevant to what we're talking about today. It's called the Financial Disclosure Law. And that's a statute that requires certain officials at the county and state level to file financial disclosure statements with the commission every year. And that's cited as Mass General Laws, Chapter 268B. But all of us who are working for government are subject to conflict law restrictions. And it applies to all of those who provide services to a public agency, whether you are appointed or whether you are elected, whether you are full-time or part-time, whether you are paid or unpaid. In other words, all of the various municipal boards that are staffed by our volunteers, even though they're unpaid, because of the services they're providing to the town, they're municipal employees for conflict of interest law purposes. They're subject to the same restrictions as the rest of us. Also, even vendors or consultants. If I were to have a contract with the town to provide services, and my services were specifically required to satisfy the contract, even though I'm a vendor, I would be a municipal employee for conflict of interest law purposes as well. So the services we provide at the commission, the most important one is legal advice. Don't be afraid to call us. Everyone else does. We get about 6,000 calls a year from public employees asking about the compliance rules. We're on the speed dial of most of our legislators and constitutional officers because they're always attending events where things might be provided that might implicate the conflict law. So they have to know on a sort of run and gun basis, what are the compliance rules in a given situation. We also do seminars like we're doing here. I do about 60 to 70 seminars for public agencies a year. Because we're an enforcement entity, we also have an investigative division, the enforcement division, and that's staffed with prosecutors and investigators. We get about 1,000 complaints a year at the Ethics Commission. They're all vetted with an eye towards, does this suggest a violation of the law? If so, how significant? And would the Ethics Commission normally resolve the matter with any type of enforcement action? Now, we are required at the Ethics Commission to operate in secret. we have strict statutory requirements that say we cannot talk about what we are reviewing at the commission. So as a practical matter, you know, we get calls from the public, we get calls from reporters asking, you know, are you reviewing this matter? Did you get a complaint? So-and-so said they called your office for advice. Can you confirm that? All of that is required to stay confidential. We can't, in order to comply with the law, we can't confirm or deny whether anyone has contacted our office for advice and what, if any, advice we have provided. We can't confirm or deny whether we've received any complaints, whether we're investigating any matters. A lot of the information that we can talk about is available on our website. It's only a limited subset of what we can talk about. Where most matters are confidential, if the commission decides that somebody's violated the law in a significant way and they issue an enforcement decision, that decision is public. Certain legal opinions are available on our website. If the commission, as opposed to a staff attorney, issues an opinion, they'll only do so if it will serve as precedent. And any legal opinion that serves as precedent, we can post on our website as long as we can successfully redact the requester's identity. All right, and so we do have a website. I really shouldn't say it's our website. It's not. It's the state portal. In all state agencies now, we're allowed to post content on the state portal. So we call it for our website just for ease of explanation. But in any event, on our content, we have some useful information. Anything we can talk about is available up on our website. Educational materials, certain opinions, decisions, disclosure forms that we're going to talk about, and also links to the mandatory education requirements. You all are or should be familiar with the online training program and the summary of the law. Those resources are provided for you to complete on a regular basis. In 2009, the law was amended to require that all public employees regularly undergo training on the conflict of interest law. Simply a recognition that the law gets fairly complicated and there can be serious penalties for significant violations. And we want to make sure that the public can have confidence in the work that we do by knowing that public employees have received training in all of the relevant statutes that can apply to how they perform their duties. And conflicts of interest can impose significant restrictions on how we can perform our duties. So say you are doing your job and you encounter a conflict of interest. A matter comes before you and it's going to affect the financial interest of an immediate family member, or it's a matter that affects a friend, or it affects your neighborhood, or your church, or what have you. A conflict of interest. And you need to contact the Ethics Commission for advice, and we encourage you to do so. Understand that where we get about 6,000 calls in a year, for the most part, it's a 5 or 10-minute phone call, or it's a quick email exchange. You know, we receive the facts, and on the basis of those facts, we'll provide information. But there are a couple of ground rules when people call our office for legal advice. It's confidential, and it's binding on the commission. We are bound by the advice that we give, so we can't say that somebody's violated the law if they got advice from us and they're following that advice. But the ground rules are, we don't give out third-party advice. We're required to keep matters confidential. We can tell you how the law will apply to your situation. We can't discuss with you how the law applies to someone else's situation. We also do not give out past conduct advice. Understand, conflicts of interest happen every day in government. They may never happen to you, but they happen every day. They're not to be feared. You deal with conflicts of interest by managing them. You manage conflicts of interest by getting out in front of the situation. And the first part of that is knowing when the red flag should go up, and then not doing anything until you understand what the compliance rules are, if any. And that could involve contacting the Ethics Commission for advice. So if you do find that a situation comes up and you do need advice, you've got to get that advice before you perform your duties that might implicate the law. It doesn't do you any good to violate the law and then get an opinion afterwards. The opinion has to be in place beforehand. And like conflict of interest law disclosures that I'm going to talk about further, they have to be in place before you engage in any conduct that might implicate the conflict law. Okay, so past conduct stuff, you know, we get calls like that once in a while where somebody already engaged in conduct that implicates the law, and then they call our legal division for advice afterwards, and our legal division will defer any advice because they're only authorized to give advice prospectively. Once conduct has already occurred, it then falls within the purview of our enforcement division because they're the ones that determine whether the law has been violated. Now, understand, we don't want to create any barriers to people calling our office. So we have a strict wall between our enforcement and legal divisions, even though we're a small state agency. When it comes to giving legal advice, if our legal division learns of an actual violation or possible violation, they will not report it to our enforcement division, because to do so, people wouldn't call us, and that does not serve the public interest. So just take that to heart, but call before you engage in any conduct that might implicate the law. Okay, disclosure. Disclosure as a way to deal with a conflict of interest. So with certain sections of the law says, no, you cannot. You know, we're going to talk about gift restriction rules that say, no, you cannot. But where a conflict of interest might present itself and the law allows you to do something, chances are a disclosure will be required because you're required to serve the public interest, and there's a public record of how the public's business is conducted. If a public employee who's participating in the public business has a conflict where the law allows them to continue to do their job, they will have to disclose that conflict. Any biases that public employees have to become part of the public record of how the public's business is being conducted. So say you encounter an appearance of a conflict of interest. You're going to sit on a board, or you're working for inspectional services, and your neighbor has filed a permit application to tear down their home and build a new home. Now that's a nepotism issue for you, I would imagine, but let's say it's not for the sake of the example. You have an appearance of a conflict of interest because you're being asked to perform your duties and you have a private interest in the matter. The issue affects a neighbor, and the public looking at the circumstance will wonder whether that neighbor is going to get any unwarranted preferential treatment, for example. For appearances of conflict of interest, the law says you are allowed to continue to perform your duties, but if you do, you must have a written disclosure in place first. And this disclosure form is representative of various disclosures that the Ethics Commission has available to you should a situation come up. But understand, to comply with the law, any disclosure of a conflict, of a bias, has to be in writing. That disclosure has to contain all the relevant facts. Now, we've done all the work with these forms that have all the information, all of the questions for you. All you have to do is fill in the particular details. We've done the rest of the work. But you have to fill out all of the relevant facts that constitute your conflict or your bias. The disclosure has to be submitted in advance. Again, getting out in front on these situations. For our purposes, where we are appointed to our positions, any conflict of interest disclosure is submitted to our appointing authority. That person who's responsible for appointing to our particular position. It could be the town manager, it could be the board of selectmen, it could be an agency head or whatever. But whoever appoints to your particular position is your appointing authority. And so if you have to file the disclosure, that's where it would go. For elected officials who do not have appointing authorities, we advise them to file a conflict law disclosure with the town clerk's office. Those disclosures are public records. They become part of the record of how the public's business is being conducted. Okay. Jim, I can, as I said, I'm not monitoring the chat, so if any chat questions come up, feel free to let me know and we'll deal with them. Otherwise, we're going to dive in.
Dave, if I could, before you go forward, I was waiting for this break, but
okay.
I'm not able to monitor the chat because, as you appropriately noted, I made you the host, so I'm now just a passive participant. So if you can make me the host, again, I've made it so you can still screen share, but then I'll be able to babysit the other functions.
Okay, let me see what we can do with that. I'm gonna go to Jim and I'm gonna make Jim the host.
Lovely, thank you.
Okay. Now let's see if that eliminates my screen share options. Hopefully no. Okay, so you should be able to click on that chat icon and the chat should appear on the right-hand side of your computer screen, and
Indeed.
any
Yep.
questions come in. So if anyone has submitted a question by the chat, just unmute your microphone and go ahead and fire away. That way we won't miss anything important. But having said that, let's now dive into the conflict law. So there are gift restriction rules in the conflict law. The question being, can I, as a public employee, accept a gift from someone? The answer to that exciting question, it depends on the circumstances. Some circumstances are prohibited, some may be allowed, but a disclosure is required, and then others, no issue. But the general restrictions are as reflected on the bulleted items here on this slide. Bribes, that's intuitive. We all understand what bribery is. And under the conflict of interest law, public employees may not solicit or receive bribes. And the people who might be predisposed to are prohibited by law from offering or giving bribes to public employees. Now, bribes are corrupt acts. You know, by their nature, a bribe is designed to get a certain result using some item of value, cash or some other type of gift or item of value. Now, bribes are obvious efforts to corrupt public employees, to corrupt the public process. And because of their obvious efforts to corrupt, it's the most serious violation under the conflict of interest law. Reflecting that, where the Ethics Commission, exercising its enforcement authority, can impose civil penalties of up to $10,000 for significant violations of most sections of the law. For this bribery section, no, it's $25,000. And both parties would violate the conflict law and would be subject to these penalties. Also, the deal doesn't have to be consummated. The mere attempt, the mere offer, the mere solicitation is sufficient to trigger the violation. The middle bullet point deals with what we commonly refer to as the $50 rule. So bribes, it's easy stuff. The middle one deals with illegal gifts and gratuities, and it basically says that in connection with your work as a public employee, if somebody were to offer or give to you some item of value that's valued at $50 or more, and there's some business connection between you and the gift giver, the gifts are prohibited. This $50 rule. The conflict law is designed to restrict situations where public employees who are supposed to be serving the public interest could be improperly influenced in how they perform their duties because of the receipt of a gift. Where you would decide a matter 10 out of 10 times a certain way, would you decide it differently because the person you're dealing with provided you with a gift? Now, establishing at what value could a public employee be improperly influenced is a moving target that nobody can hit. This $50 rule has been around since the 1970s. It came about through a court decision, but everybody gets the $50 rule. And so the commission has the term in the statute is an item of substantial value. And the commission has defined that to be anything worth $50 or more. And it's gifts worth $50 or more given for or because of official acts performed or to be performed. And that doesn't establish a quid pro quo because that would be bribery. All it does is say that there's some business connection between the gift giver and the public employee. There's some business nexus motivating the gift, but there's no quid pro quo. These, gifts to say thank you, express appreciation, what have you, but not bribes. The bottom bullet point takes out the business connection. The bottom bullet point is sort of the threshold gift restriction rule. If we understand nothing else, we need to understand this one. Public employees cannot solicit or receive anything of value that's worth $50 or more and given because of official position. In other words, even if you have no dealings with a gift giver, if somebody gives you a gift because of who you are as a public employee, it is prohibited. Now, under this bottom bullet point, it's only the public employee who violates the law because the person giving the gift, they have no skin in the game, so to speak. They're not looking for anything. Under the bribery and illegal gifts and gratuities section, the person offering the gift, violating the statute, would violate the statute. The public employee could violate, and also the giver. Under the bottom bullet point, it's only the public employee. So that's it in a nutshell. Public employees cannot accept any item of value if it constitutes a bribe. Public employees cannot accept any item of value that's worth $50 or more that's connected to some public business with the giver, or that is given to the public employee just because of their official position. Simple enough, right? I wish. Okay, so the $50 rule is there. So what about gifts worth less than $50? The conflict law doesn't prohibit us as public employees from accepting some item of value worth less than $50 unless there's a quid pro quo attached, and hopefully nobody would offer or accept a bribe for 40 bucks, for example. But if there's a quid pro quo, it doesn't matter what the dollar value is. But otherwise, we can accept gifts worth less than $50. Now, if it creates an appearance of a conflict of interest, while we can accept the gift, we then have to disclose that appearance of a conflict. Now, what does that mean? Well, the example I used to illustrate the point would be that of a school teacher. Say I'm a school teacher, a municipal employee, and the parents of one of my students have given me a $40 gift certificate to my favorite restaurant. I can accept it because it's not worth $50 or more. If it were, I'd have to refuse it. But it's $40. I can accept it. Does it create an appearance problem? Because if the answer is yes, then I have to file a disclosure with my boss, the principal. But not all circumstances create appearance problems. For example, if I get that $40 gift certificate at the end of the school year, so that as a teacher, where I have official dealings as a teacher with parents, with students, with colleagues, and so forth, if it's at the end of the school year and I'm not going to have any further dealings as a teacher with the parents, it doesn't create an appearance problem. Because the appearance problem is not created upon receipt of a gift worth less than $50. The appearance problem is created after receiving the gift and up to the point where I'm next going to have official dealings with the giver. At that point, before I have any further official dealings with a gift giver, I have to have that written disclosure in place, because at that point is where the appearance of a conflict of interest is created. So if, for example, I were to receive that $40 gift certificate from the parents in the middle of the school year, where I am going to continue to have dealings with the parents and the student, it does create an appearance problem. You know, for example, what if the parents, in connection with giving me that gift certificate, have asked me to write a letter of recommendation for their child? They're trying to get their child into a competitive AP class, for example, and a letter of recommendation from a teacher is required. And what if many of the other parents have made similar requests and I can't write that many letters? Now here we have the circumstance where the gift certificate attaches to this request. What will the people looking at that circumstance conclude? What will the other parents who didn't give me a gift certificate think about that circumstance? It erodes confidence in government. And that is why, where an appearance problem is created by the receipt of a gift worth less than $50, a disclosure with my appointing authority, the principal, would be required. If I don't want to have to file that written disclosure, I would just refuse the gift. You have to make those judgments as you go along, but you want to think about that. And if there's any question, you want to call us. Okay, gifts that may be prohibited. These bulleted items are the most common issues we deal with at the Ethics Commission in terms of public employees accepting gifts: the payment of meals, event tickets, free travel or expense reimbursements, gift certificates, floral arrangements, you know, if you're dealing with vendors, fruit baskets and so forth. The public, especially in this time of COVID, our first responders, our medical personnel, we want to do nice things for them. Lottery tickets, gifts offered through sales promotion. Any item of value in any way, shape, or form conveyed from one person to another, whether it's tangible or intangible, can technically be an item of value that implicates the conflict of interest law. Beside that second bullet point, event tickets, you'll see a reference to an advisory. The Commission from time to time issues advisories, which is nothing more than generalized legal advice. Where we get a ton of similar questions about a topic, the Commission may endeavor to be efficient. Instead of having our legal division attorneys deal with those questions one-on-one, they might issue an advisory, which explains to public employees how the conflict law applies in a given situation. It did so in 2004 concerning event tickets because of what the Patriots and Red Sox did starting in 2003 and going forward. We were getting a lot of calls from public employees who were getting invited by vendors to attend the playoff games, World Series, Super Bowl, so on and so forth. And so we were getting a lot of calls about that. So the Commission issued this advisory, and it explains, things like, face value of a ticket, where the Commission explained that, we're not going to go with face value. We're going to go with the maximum value. And if the value to attend an event exceeds the face value by $50 or more, that's going to be problematic. And so the advisory is available on our website, and it explains to public employees how the conflict law applies in connection with anyone offering you tickets to an event. Understanding that the $50 rule applies. If the value to attend the event or the cost, what have you, is $50 or more, you just can't accept it. It's an outright prohibition. Okay, lottery tickets, quiz time. So somebody comes up to you in town hall and you don't have any business dealings with them. You just know them from town hall. You have known them for years and you exchange pleasantries. And one day they come up to you and hand you a $50 scratch ticket. Can you accept it? No. If it's given to you because of your official position and it's $50 or more, it's prohibited under the conflict law. What happens if you succumb to the temptation and you scratch that ticket? You accept it and scratch it and it comes up goose eggs. It still costs the giver $50. So it's prohibited, even if you don't win anything. What, however, if they come up and give you a $2 scratch ticket? Well, it only cost them $2, so you're not prohibited from accepting it. What happens if you scratch the ticket and you win $10,000? Well, it's your lucky day. It only cost them $2. But does that situation create an appearance of a conflict of interest? Yes. And so while you can accept that, you will have to file a written disclosure with your appointing authority. Gifts offered through sales promotions. We had an enforcement case against a food services director in one of our school districts who, rather than only ordering the amount of food from the food wholesalers that the school department needed, succumb to the inducements, the sales inducements that these food wholesalers are putting out there, saying, you know what, if you just up your order level a little bit more, you'll qualify for these valuable prizes, which at the time were iPods and mini iPods, the music devices put out by Apple that were all the rage years ago. And so this food services director ordered enough to qualify for the iPods and then kept them for her personal use because she thought they would make great gifts for the grandchildren. I don't think she appreciated the ramifications because the commission took enforcement action when it learned of what she did, and then she also lost the job. You want to be careful about accepting any item of value from anyone that you have dealings with as a public employee. Now, there are workarounds under the conflict of interest law, and the commission, recognizing that not all circumstances where a public employee might accept something worth $50 or more, where there is no conflict of interest mischief, but yet since it's something worth $50 or more, it would technically violate the statute, where those issues, since they don't raise some conflict mischief, that workarounds could be created. And so over the last several years, the commission has promulgated regulations that say, in certain instances, public employees can accept items worth $50 or more that are given because of who they are as public employees, and it will not violate the gift restriction rules, provided that the public employee follows the regulation that's been promulgated. And so these bulleted items are categories where exemptions from the gift restriction rules are available to public employees. And I'm not going to talk about all of them, but just a couple. The top one is travel expenses. That's the most common one that public employees use. The ability of public employees to attend training opportunities, educational opportunities, conferences, where the event themselves serves a public purpose. It will help the public employee learn how to do their job better. Under the regulation, public employees can attend these events and have third parties, someone other than their agency or themselves, pay the expenses without violating the gift rules. The gift rule is you can't accept anything worth $50 or more given because of your official position. But the regulation says as long as it's in connection with an event that serves a legitimate public purpose, in other words, the public agency is served by your attending the event. You can go and have some private entity such as a vendor pay your expenses as long as you file a written disclosure of the event and the reimbursements or the prepays with your appointing authority, and your appointing authority acting on behalf of the agency determines that your attending the event serves a public purpose, a legitimate public purpose. So although the conflict law gift restriction rule is implicated, by following the regulation, it will not violate the conflict of interest law. Same thing applies to incidental hospitality. You know, you get invited to some event, some open house, that's a part of what you do as a town employee, and some host, a third-party entity, some private entity is serving food and beverage. Public employees will get all worked up about those issues. Can I go? Can I accept a cup of coffee? Can I accept pastry, what have you? So the commission, by regulation, alerts the public and public employees that yes, you can. You know, as long as the event serves a public purpose and it's not some whining and dining or junket type of event, as long as it's a legitimate educational event or informational event or what have you, and it's a natural part of what you would do as your public position, you can go. And if any hospitality is served, you can partake. You just file a disclosure with your appointing authority. You let the boss know in writing. Okay, this is the meeting, this was the event, and the host served food and beverage, what have you. Random drawings are allowed because the conflict law is concerned about gifts given to you for your personal use, where there might be an effort to undermine confidence in government by leveraging a relationship with you. You know, would the situation cause you to become improperly influenced where you might decide matters differently because somebody did a nice thing for you? When you're talking random drawings, there's no such circumstance. You know, you attend a conference and some third-party entity is offering an iPad as a door prize. You know, nothing's being targeted to you. So random drawings don't implicate the gift restriction rules. Unsolicited perishable items. And, you know, this happens, you know, especially if you're a public employee dealing with vendors. All of a sudden, you know, you're dealing with a vendor on an IT project, for example, and out of the blue, a floral bouquet comes up or an edible fruit basket. Recognizing that these are not efforts to corrupt public employees, but also recognizing that the $50 rule is implicated in these kinds of circumstances, the commission promulgated a regulation that said public employees can accept unsolicited, that being operative, perishable items, food items, other types of items like floral bouquets, as long as, excuse me, they're not accepting those items for their own personal use. As long as they're accepting those items on behalf of their public agency, on behalf of the town, for example. How do you do that? You share the items. You receive it and you share it with everyone who normally frequents the office or what have you. So if you were to receive a floral bouquet from a vendor, it doesn't go into your office. You don't get to take it home. It goes out in the lobby of your office or the lobby of town hall or what have you. If you receive an edible fruit basket from a vendor, for example, You get to take it to your office for the limited purpose of culling out all the chocolate-covered strawberries and then leaving the apple slices and pineapple for everyone else. But as long as you're accepting it on behalf of the agency, you're making it available to everyone, and you're not using it for your personal use. Although you're grabbing all the good stuff. But in any event, that's how the regulations work. Normal everyday situations implicate the gift restriction rules, but there's really no harm in these circumstances, and regulations are in place to say if these circumstances are present, it won't violate the conflict law. As I said, I'm not going to talk about all of these issues, but these bulleted items are additional categories where exemptions from the gift restriction rules are available to public employees. Okay, that takes us from the gift restriction rules to the nepotism rules. And as I indicated earlier, the conflict of interest law says that if certain financial interests are affected, you are prohibited from performing your duties. The law says that you as a municipal employee may not participate in any matters that affect the financial interests of you, your immediate family members, a business partner, a business organization that either employs you privately or that you own or operate, or the financial interests of anyone with whom you're negotiating for employment. And so the conflict of interest law says you're out. You must abstain or recuse from those circumstances. But there is a workaround. In certain circumstances, not all nepotism issues are significant. Some of them involve fairly routine or administrative matters. And so the workaround says that when you encounter a nepotism issue, you must step back. But you have the option, you can file a written disclosure with your appointing authority. And if your appointing authority says it's okay in writing for you to participate, then it waives the statute. Like, for example, so say I'm a department head for the town and one of my family members happens to work in my department. Now, I didn't hire them and I don't supervise them. Those are serious nepotism issues if they're an immediate family member. When they were hired into the department, I wasn't the department head. I then got the promotion. One of the things I have to do as department head is certify the payroll for my department once every 2 weeks. Now, that constitutes my signing off on a piece of paper. It's a routine administrative matter. But nonetheless, by signing off on that piece of paper, certifying the payroll for my department, everybody gets paid, including my family member. That's a matter that affects the financial interest of a family member. It's a nepotism issue. But recognizing that it's a routine administrative matter, the workaround under the law says, if you encounter that situation, you step back, but you can file a written disclosure of that nepotism issue with your appointing authority. And on that disclosure, if your appointing authority wants to make a determination that it's okay for you to handle the matter, it waives the statute. When you provide that disclosure to your appointing authority, they can do one of three things. You have to stay out of the matter. So they get to decide what to do, and they can do one of three things. They can take responsibility for signing the payroll or certifying the payroll and handle it themselves, or they can assign someone else to handle it. But the third thing they can do is if they can make a determination, if they wish to make a determination and put it in writing on your disclosure, that the integrity of the services that they can expect from you are not going to be affected by your handling the matter, even though you have a nepotism issue, it waives the statute. By filing disclosures of conflicts of interest, it creates transparency so the public can see that public employees are not handling matters with any hidden or undisclosed biases. The cards are on the table. And then by filing the disclosure with the agency, it creates transparency with the agency. It then puts the agency via the appointing authority on notice that this issue, that this employee has this issue. And then it allows the agency to manage the conflict. And on this nepotism workaround is to decide which course of action to take when one of the employees has a nepotism issue. Now, agencies can manage conflicts of interest so that situations don't blow up, but they can't manage what they don't know about. And that's why the conflict law requires disclosure by the public employee to create transparency, and then action by the agency to deal with the issue. And that helps to ensure confidence in government. If you are elected to an office in your town, you don't have an appointing authority. So this disclosure determination process, this workaround for the nepotism section of the law, is not available to elected officials. Okay, immediate family members. The statute says that a municipal employee may not participate as such in any matter that affects the financial interests of, among others, immediate family members. That term is defined in the law, and it's reflected here on the chart. And who are your immediate family members? Well, first and foremost, you, but then also your spouse, and then your parents and your spouse's parents. Also your siblings and your spouse's siblings, and your children, your closest in relatives. You may not, as a town employee, handle matters affecting your financial interests or their financial interests. It violates the nepotism section of the law. Now, this then begs the question, well, what about other family members that I have who are not immediate family members? We'll call them non-immediate family members. What does the conflict law say about my ability to deal with matters that might affect the financial interests of a non-immediate family member? Now, first of all, who are they? Cousins, aunts and uncles, nieces and nephews, grandparents, grandchildren, ex-spouses, domestic partners. Not on the chart, not an immediate family member. Not an immediate family member, not a nepotism issue. That doesn't mean it's not a conflict issue. It all depends on what bucket it is going to involve. And I talked about those two buckets early on, nepotism and appearances of conflict of interest. Does it create an appearance problem if you were to handle a matter that, say, awarded a contract to your cousin's company, where your cousin would financially benefit by that contract? Of course it would. And so you're allowed to participate in matters affecting the financial interests of non-immediate family members or friends, provided that you first disclose the conflict with your appointing authority. The nepotism section says, no, you're out. The code of conduct section says you can, provided you first file your disclosure. It gets a little tricky. And that's why when situations come up, you want to call our office and we'll sort it all out for you. So moving from the nepotism section to the code of conduct section, I've talked about appearances of conflict of interest. That first bullet point contains a statutory provision guiding this principle. It says that you as a municipal employee may not act in a manner such that a reasonable person, knowing all of the circumstances, could conclude that you might act with bias, that you could be improperly influenced in the performance of your official duties. Now, improperly influenced means while you're supposed to handle matters objectively and following all of the rules, the bias might suggest that you would decide matters or could decide matters differently because this issue affects some component of your private life. And then it further provides that if you put the cards on the table in advance, you file a written disclosure of that conflict, of that bias you have, it dispels the appearance problem. So if you were to handle a matter and it affects some component of your private life and you don't disclose it, it's reasonable to conclude that you were improperly influenced. But as a matter of law, when an appearance comes up and you file that disclosure in advance, the act of disclosure dispels the appearance problem. What that means is it's no longer reasonable to conclude that you were or could be improperly influenced because you put the cards on the table in advance. This code of conduct section also has other provisions. What happens if you do use your position to grant or extend or provide unwarranted benefits to those people that you're connected to? Well, that would constitute an improper use of your public position. The conflict of interest law under the code of conduct section also says that a public employee, a municipal employee, is prohibited from using their official position to secure for themselves or others unwarranted privileges that are of substantial value, that means $50 or more, and not available to similarly situated individuals. In other words, if to the extent in your position you can convey benefits to anyone, you have to follow the rules. In any situation where a public employee deviates from the normal rules that guide what they do, and as a result of that deviation, somebody they're connected to benefits by $50 or more, it's an unwarranted privilege. So say I work in town hall and I issue a beach sticker, and the beach sticker costs $100 to get it over the $50 rule. And everybody has to come to me with an application and pay the money. And one day my Uncle Harry comes in and he wants a beach sticker, and I tell him, Uncle Harry, today you get it's your lucky day, today you get the friends and family discount. Fill out the application, you won't have to pay the fee, everybody else does. Well, in that instance, I've improperly used my public position to secure an unwarranted benefit for someone I'm connected to, my Uncle Harry. Why is it an unwarranted benefit? Because I'm required to follow all the rules. I'm not authorized to give out a friends and family discount. And so where I've deviated from the rules, and as a result, my Uncle Harry benefited by $100, it violates the conflict of interest law. It constitutes an improper use of my public position. This principle, this use of official position to secure unwarranted privileges, also extends to using public resources for a non-public purpose. Public resources, facilities, equipment and supplies, vehicles, what have you, may only be used for the conduct of the public business. Any abuse of use for non-public purposes violates the conflict of interest law. And this can extend to using public resources for campaign and political activity, which we'll talk about in a minute. The bottom bullet point deals with improperly disseminating confidential information. It would be an improper use of one's public position to improperly disseminate confidential information learned in the course of their public employment and disseminating it to anyone who's not authorized to receive or review it. Now, inadvertent disclosures would not necessarily constitute a violation of the conflict of interest law, but the conflict law would be violated if a public employee improperly disseminates confidential information to further a personal purpose. And so by way of example, we had a case which involved a district court clerk. And the issue involved query information. Now, this clerk had a relative who was running for an election locally. And clerks don't have access to query information. But one day this clerk went to someone who does have access to query information, probation officer. She asked the probation officer to run a query check on her relative's opponent in that upcoming election. She did not provide any context so that the probation officer would know that it wasn't official business. Probation officer runs the query check, gets a hit, an arrest record, which he then provides to the clerk, who then provides it to her relative, who then releases it to the media. Guess who wins the election? We learn about it after the fact. Now, the Ethics Commission does not get involved in undoing elections. We only can take steps to enforce the conflict law on public employees. So the Ethics Commission investigated the matter and found that the clerk violated the conflict of interest law. In its decision, the commission said, Madam Clerk, respectfully, even though you are not authorized to receive query information, once you did receive this information under false pretenses, you were obligated to keep the information confidential. Instead, you disseminated it to someone not authorized to receive it, and you did so to further a personal purpose. Also understand that this restriction applies even if you were to leave town service. The Ethics Commission, as a law enforcement agency, has a 6-year statute of limitations. If you were to learn confidential information as a public employee and then leave your public position, and then 3 years later, you improperly disclose that information to somebody who wasn't authorized to receive it, that's still actionable. What you learn that is confidential stays confidential. Okay, political activity. You see the reference on this slide to an advisory. Again, the commission issued generalized legal advice to public employees explaining how the conflict law applies to political activity. And the general rule is, under both the conflict law and campaign finance law, public employees are prohibited from engaging in campaign or political activity on public time, in public buildings, using public equipment and supplies. For conflict law purposes, it would constitute an improper use of public position, a use of public resources for a non-public purpose. Now, if it were that easy, it does get fairly nuanced, and that's why this advisory is valuable. And so for any of you folks who support campaigns or run for office or what have you, if there are any questions, consult this advisory. It's up on our website. It does get fairly nuanced. If you're appointed, your position, your title, is a public resource. Appointed public employees cannot use their title in connection with endorsing candidates or ballot questions or what have you, because that would convey agency endorsement, which is not allowed. If you are elected to a municipal office, however, the rules are a little bit different. Elected officials are allowed to use their title in connection with endorsements. The reason this gets kind of nuanced is because there is some wiggle room. Some political activity like ballot questions, overrides, things like that, they will have a direct financial impact on the agencies. You know, if there's a 2.5 override question to build a new fire station, for example, well, the fire department is going to be directly financially impacted by however the results of that are. There's wiggle room under the conflict law that says if you are a policymaker within an agency or department that's going to be affected by some political activity, you're allowed to use public resources in the ordinary course to inform the public discussion. Now, generally, you can't advocate. You can inform the public discussion, but you know, in connection with discussing what the budget ramifications are going to be if the ballot question passes or not, it may constitute some sort of advocacy. It gets fairly nuanced, and that's why understanding that the conflict law restricts what public employees can do in connection with campaign and political activity, but recognizing there is some wiggle room depending on the circumstances, the advisory helps. And then, you know, if you look at the advisory and have questions, then you call our office. We also have an advisory under this theme, improper use of public position. We've got an advisory in connection with public employees who establish private, commercial, or business dealings with the same people they deal with as public employees. When you're at work performing your duties, your universe of contacts are those people with whom you have official dealings, and depending on what type of public position you occupy, those people over whom you have official authority. Like if you're police, or if you're, you know, building inspectors, or if you're a manager and you have subordinates. So your universe at work are those with whom you have official dealings and those over whom you have official authority. If you establish a private commercial relationship with anyone with whom you have official dealings or over whom you have official authority, does that constitute a conflict of interest? It could. Basically, you cannot use public resources in connection with initiating or maintaining any private commercial relationships. But that doesn't mean that you can't. It just means you can't use public resources. And that includes engaging in any sort of coercive behavior, attempting to use public positions to improperly leverage relationships. Also, you cannot initiate or have ongoing discussions while you're at work or using public resources. It's all going to be done after hours. To the extent you contact someone, it's got to be done after work. Now, what happens under the conflict laws, the commission says that if you do establish a private commercial relationship with any of these folks, they have to initiate it. Now, say I'm a manager in a town department and I need my house painted, and one of my subordinates in their off time paints houses. How do I contact them? If the conflict law says that I cannot initiate the overture, how does it get initiated? Well, the person performing the private service that I want to avail myself of, as long as they have a publicly available contact number, then not using public resources, which means after work, I can contact them at that publicly available contact information and inquire about the commercial relationship. It gets a little tricky, so this advisory is available for public employees to review if this situation comes up. And just understand, as long as there's no overlap between your public position and any private commercial relationship, you're okay. But also understanding that if you have a private commercial relationship with someone, and then as a public employee, you're called upon to have official dealings with them, does that circumstance create an appearance of a conflict? Absolutely. So in connection with initiating or maintaining private commercial relationships with the same people that you deal with at work, a disclosure is going to be required in one way, shape, or form. Whether it's a nepotism disclosure or whether it's an appearance of a conflict of interest disclosure, it's going to be required. And so it gets kind of complicated, but not impossible. And this advisory helps guide public employees on what is allowed and what is not allowed. Okay, we've talked about conflict of interest rules that apply to us on the job, gift restriction rules, nepotism rules, and code of conduct rules. There are also a couple of sections of the conflict of interest law that apply to us when we're off the job, when we're handling our private stuff. Generally speaking, if we're handling our private stuff and it involves the town, think conflict of interest. The conflict of interest law has a duty of loyalty requirement that covers divided loyalties. And basically, when you become a public employee, a town employee, you have a duty of loyalty to the town that's imposed on you by the conflict of interest law. What that means is when you're off the job handling your private stuff, be it family matters, personal matters, outside business matters, you are prohibited by the conflict law from representing those private interests before the town, because it would compromise the duty of loyalty you owe the town. In addition, even if you're not representing the interest before the town, you cannot be paid by any private party to work on a matter where the town is also an interested party. So there's two components to this divided loyalties restriction under the conflict law. Representing third-party interests before the town, whether you're paid or not, but then also being paid by someone other than the town to work on a matter where the town is either a party or has a direct and substantial interest in the matter. That gets a little tricky. There's a provision in the law governing what we call special municipal employees. Anyone who serves in a town position that's not paid, or to the extent it's paid, it's for less than 800 hours in a year, or by the nature of the service provided to the town, it allows for private employment during normal business hours. The town has the ability to designate those positions as special municipal employees. The reason this is important is that it creates flexibility under the conflict law, where the restrictions are you can't. If you occupy a special municipal employee position, you can in limited circumstances. The reason why this is important really is for our board and committee members, those unpaid appointed positions or elected positions. Nobody is going to agree to engage in any service to the town on these unpaid boards if the law says once you begin serving on the board, you have to sever all of your existing business interests with the town. That's not workable. So the conflict law says for full-time employees, the duty of loyalty restrictions apply. If you occupy a position that has been classified by the town as a special municipal employee position, however, the law applies less restrictively. It allows you to continue representing third-party interests before town departments, boards, what have you, and to be paid to work on matters that involve those town departments, as long as it doesn't involve the board or agency that makes you a town employee, the one that you serve. That gets fairly complicated, but we can sort it out. It just takes a little bit of thought. Now, second bullet point here on this slide, municipal employees may always represent their own interests. Don't confuse the duty of loyalty requirement with representing yourself. You do not lose any rights because you become a town employee. What the conflict law is concerned about is your ability to use your position, your influences, your expertise to benefit third-party interests. It would compromise the duty of loyalty you owe the town. But you are always allowed to represent your own interests before any town board without restriction. Also understand that where the conflict law prohibits a town employee from working on a matter for pay, if the town is a party or has a direct and substantial interest in the matter, the conflict law also restricts those people that want to pay you to do that work. Contractors and consultants cannot compensate a town employee to work on any project where the conflict law restricts the town employee. Okay, there are some carve-outs, some workarounds, so to speak, from the duty of loyalty restrictions. Personnel or disciplinary issues. Even though your duty of loyalty is to the town, if a co-worker gets jammed up, you can provide assistance without violating the conflict law as long as you're not paid to provide that assistance. Also, you can represent your family members before town departments, but your appointing authority has to say it's okay first. You're allowed to provide testimony or sworn statements in any judicial or quasi-judicial proceeding without violating or compromising the duty of loyalty you owe the town. There's also a provision that says a state or county employee can also be a town employee. But there are restrictions. Any state employee who's also a town employee, when they're acting in their municipal capacity, they have to stay out of matters within the purview of the state agency that employs them. And similarly, any municipal employee who's also a state or county employee, when they're acting in their state or county capacity, they have to stay out of matters within the purview of the municipality. Gets a little tricky, but that's why we're here to explain how the law can apply. There's also a general carve-out that says any employee except those who are employed by the permit granting authority or department. Otherwise, any employee can pull a building permit, electrical, plumbing, gas, septic on behalf of others. You can be a contractor where you're acting as an agent for the property owner. You can pull those permits without violating the duty of loyalty requirement, as long as you're not employed by the permit issuing department or an agency that oversees the activities of that permit issuing department. There's also a regulatory exemption related to this divided loyalties restriction. If you work for the town and say you have children in the school district, you're allowed to advocate for them without violating the conflict of interest law. If you are a town employee and you are occupying a supervisory position, you can advocate for your children before the town, but you do have to file a disclosure with your agency concerning that circumstance. And if by filing a public disclosure, it would necessarily call for you to disclose confidential information, there is a provision for allowing the conflict law disclosure requirements and confidential information to peacefully coexist. For example, say you have a child in the school district and they're receiving services under an IEP. Now, all that stuff about school children and IEPs is strictly confidential under both federal and state law. So what happens if you're a town employee and you want to represent your child, you want to advocate them before the school department regarding the IEP? Well, if you would have to file a disclosure, it would necessarily call for you to disclose confidential information, but no, you don't have to. There's a process where you fill out a disclosure with your agency, but any disclosure that is publicly available is redacted so that the confidential information is not released in connection with the public disclosure. It gets a little tricky, and that's why people call us. The second conflict law provision that applies to us when we're off the job, not really off the job, it's just having stuff going on with the town in a different capacity. It deals with financial interests and contracts, prohibited financial interests and contracts. The conflict law says that a municipal employee is prohibited from having a financial interest in a municipal contract. The conflict law is concerned about what we call inside track situations, where public employees can use their public positions to gain an inside track on additional public compensation. So the conflict law restricts that. But that language is so broadly written, it encompasses a whole bunch of stuff not designed to be restricted by the conflict law. But that's the language of the statute. That's what we're having to live with. The statute says a municipal employee may not have a financial interest in a municipal contract. Now, having a financial interest in a municipal contract can come in the form of either a second paid municipal job or acquiring a financial interest in a vendor contract, being awarded a vendor contract by a town department. This is the most confusing section of the law because the law is so broadly written, but it also has most of the regulations and exemptions. So the basic issue, can I as a public employee take on a second paid public job or work on a vendor contract or acquire a financial interest in a vendor contract? When we get those calls in our legal division, the default answer is no, unless you qualify under an exemption. But whether you qualify under an exemption depends on a detailed analysis of all of the available facts. Don't assume the answer is no. Because if position one and position two, if there's no overlap, or if there's no overlap between your town position and the vendor contract, chances are there's going to be a workaround. There's going to be an exemption or a regulation that will let you do that. So don't assume the answer is no, but understand the red flag needs to go up and you do need to find out whether the law applies. There's a provision in the law that says that you can be a full-time employee under certain circumstances. If you are a special municipal employee, you have greater wiggle room under this section of the law as well. A special municipal employee can take on a second paid or a paid municipal position, and all they have to do is file a disclosure of that paid position with the town clerk, not their appointing authority, but the town clerk. This restriction on acquiring a financial interest in a second contract by holding another position does not apply to elected positions. You're not deemed to have a contract with the municipality if you are an office holder, an elected office holder. It also, if you're appointed to an unpaid position, obviously there's no financial interest in a contract with the municipality. There's also an exemption that says any full-time or part-time or any town employee can also serve on the Board of Selectmen. But if you are a full-time town employee and you run for and win a seat on the Board of Selectmen, you are required to observe 3 conditions when you're serving in both capacities. Number 1, when you're acting as a member of the Board of Selectmen, you have to stay out of matters within the purview of the department that otherwise employs you. So say I'm a firefighter in the town and I run for a seat on the Board of Selectmen and I win. When I'm acting as a selectman, I've got to stay out of matters within the purview of the fire department. That's condition 1. Condition 2, to deal with the inside track situation, I can only take one pay. I can't be paid from multiple sources. I have to decide whether I want to continue to receive my firefighter pay or do I want to instead accept that measly stipend they pay the selectmen. But I have to choose which pay I'll continue to receive. The third condition deals with my ability to be promoted or to accept any other appointment. The conflict law says that if I am a town employee who's also serving on the Board of Selectmen, I am prohibited from being appointed to any other position within the town while I serve on the Board of Selectmen and for 6 months after I leave the board. So if a promotional opportunity comes into the department, I can't accept it, even if I'm the odds-on favorite to get it. I cannot accept it. Okay. If there is any overlap between position 1 and position 2, for example, and you occupy, and you're not a special municipal employee, and there is some level of overlap, you may still be able to take on that second paid public job or acquire the financial interest in the vendor contract. It would require filing a disclosure of the second paid job or the vendor contract with the town clerk's office, but it may also require the Board of Selectmen to waive the statute to approve of your holding a second paid municipal job or acquiring a financial interest in a vendor contract. In other words, if there's any overlap between position 1 and position 2, you can't do it unless the town says you can do it by a vote of the Board of Selectmen. And if you're a full-time municipal employee, you can take on a second paid job or an interest in a vendor contract as long as there's no overlap. And these bullet points sort of identify what the criteria are for there being no overlap. The third bullet point there is important though. The contract, the second public position or the vendor contract has to involve some sort of public notice or competitive bidding. So how can a school teacher or a coach in the school department work for the summer Parks and Rec program? They can, but they have to follow these guidelines. And the number one thing being the contract for the positions, for the Park and Rec positions, have to be publicly noticed. They've got to be put out there for people to apply, and then, you know, our coaches and school teachers can apply for those summer jobs as well. Okay. And in connection with any additional contract that an existing town employee has, you know, an existing outside contract, if it's for personal services, you're limited. You can't work more than 500 hours during a calendar year in connection with a personal services contract with the town. And again, there can't be any overlap. You can't be performing the personal services contract work while you're also working in your primary municipal job. And there's also a requirement that says the head of the agency that awards the personal services contract, they've got to file a certification with the town clerk that they don't have an existing employee within the agency that can do the job that they want you to do under that contract. And then the fourth, the Board of Selectmen have to approve an exemption to allow you as a town employee to also work on a personal services contract for this other department. It gets tricky. The main thing is, it's not impossible, it's doable, but you have to understand sometimes complicated restrictions or compliance rules within the conflict law. There are also a couple of the regulatory exemptions regarding to this public employee acquiring a financial interest in an additional public contract, fee-based contractual relationships that the town offers to the public. If I'm a town employee who has this conflict law restriction, I would ordinarily not be able to participate in a contractual relationship that the town offers to town employees, such as, you know, a beach sticker, such as a membership in a municipal golf course, things like that. But by regulation, the commission has said as long as the town employee follows all of the rules that the public has to follow, they can participate in any contractual relationships that are readily available or offered by the town to the public. And senior work-off programs, senior tax abatement programs. What if I'm a town employee and the town has a senior work-off program? I could not participate in that. It would constitute a prohibited financial interest in a second contract with the town. By regulation, the commission has said town employees can participate in senior tax abatement programs as long as they otherwise qualify. Number one, they have to be seniors. And then the ability of town employees to also participate in any town affordable housing programs or community development programs that would otherwise implicate this restriction under the conflict law. By regulation, they can participate along with everyone else as long as there's no unwarranted preferential treatment involved and they follow all of the rules. Okay, we're running a little bit over. We started late, so we're actually going to be right on time finishing up, and I thank you for your patience. We're now going to talk about the final restriction under the conflict of interest law, revolving door restrictions. Now, what's a revolving door? Well, it's public employees who leave their public positions today, and then tomorrow they go through the revolving door, only now they're representing some third-party interest before the agency they just left. Can they do that? And the answer to that exciting question is, it depends on the circumstances. The conflict law lays out two basic restrictions, the forever ban and the 1-year cooling off period. The forever ban says that if you leave your town position and then you want to go through that revolving door and now you want to represent clients in matters before your former town department or agency, you may never do so as to matters that you worked on as a town employee. When you go through that revolving door and you're representing a client, if it is in connection with a matter that you worked on, a matter that you participated in, you are prohibited permanently. The 1-year cooling off period applies to matters that while you did not work on them, they were nonetheless under your official responsibility. If you are a department head in the town, or you serve on a board, planning board, for example, matters that are pending before the board or matters that are pending within your department are matters that are under your official responsibility as a board member or a department head. But you don't necessarily participate in all of those matters. For whatever reasons, there may be some matters that are under your official responsibility, but you never touch them. If you then leave your town position and go through that revolving door, you must wait 1 year before you can represent a client or a new employer as to matters that while you didn't touch them, they were nonetheless under your official responsibility. Why? Again, when you leave your department, you still know stuff, you know people. And the conflict law says you cannot use that to benefit third-party interest. You wait 1 year and all of that stuff dissipates somewhat, you can then represent the third-party interest before the town. Okay, I referenced earlier about the conflict of interest law education requirements. We have the conflict of interest law online training program in 2021 is going to be the new compliance cycle where we're all going to have to complete that again. We've got the summary of the law that has to be provided to you by the town every year, and you have to sign off that you received it. You have to acknowledge to the town that you received that summary. The final slide, when in doubt, panic. Now, don't panic, but understand that this law gets a little complicated, and all you have to do is know when the red flag goes up. In other words, you don't have to be an expert in the law. That's our job. We're the resource. All you have to do is know when to call us. And so when a situation comes up, understanding the red flag needs to go up, gift restriction rules, nepotism rules, code of conduct rules, duty of loyalty requirements, restrictions on acquiring a financial interest in another town contract, or revolving door restrictions. And so when a situation comes up, don't guess, because if you guess and guess wrong, oops. And we want to not have those oops moments come up. So that concludes my slide presentation. So I'm going to stop sharing. We're now back to the Brady Bunch view, and we'll use this opportunity. Thank you for your kind attention. And if you have any questions, we can take them. So Jim, I'm looking at the chat section. Can I pull from, we have just basically one question.
I have a couple of others, David, that I can read into the record as well. But if you want to just take that one that's on the chat and start there.
So the question deals with holiday baskets. You know, they're all valued at more than $50. Heck, the delivery charge now gets you up there when you're talking about a floral bouquet or an edible fruit basket. So, you know, the presumption is they're all going to be worth more than $50. So it's dropped off at the office. Can it be donated to a local nonprofit or publicly acknowledged? And the answer is generally yes. But more importantly, you can accept it on behalf of the office, on behalf of the agency, and then you can keep it. But if you want to donate it, you can as well. But it's not required. Okay. Jim, go ahead.
Yep. So next we have, how do you handle an issue where in a board member's official capacity, they have to vote on a matter that they have a personal interest in, like the setting of water rates or sewer rates or fees at the recycling center.
Very good question. Sure. So there are nepotism issues that are going to be a natural part of what my board does. Water and sewer rates. If I'm on the school committee and we're setting bus transportation fees, there's a provision in the conflict law, an exemption to the nepotism rule that says, if my financial interests are going to be affected, but my financial interest is shared by a significant segment of the population, and we use a 10% as a general rule, then I can participate even though I have a financial interest. So if I'm on the Water and Sewer Commission, yes, my financial interests are going to be affected, but so is everyone else who's paying the rates. So as long as the financial interest is not unique and distinct to me, but rather is shared by a significant portion of the population, and we use 10%, it won't violate the conflict of interest law. And that's no disclosure, no nothing. It's a flat out exemption in the law that says the law does not apply if your financial interests are shared by a significant portion of the population.
Excellent, thank you. The next, David, is if the community enters into a contract with a vendor, as an example, an oil company for the town's heating for the season, and the oil company offers the same discounted rate that the municipality receives to municipal employees, are they eligible to accept such a rate?
It depends. If it's offered broadly to all municipal employees, generally that may be accepted. But if it's restricted to certain class, then it won't be. So, and also understand the municipality isn't paying sales taxes. And, you know, anything offered, you know, the sales tax rules would normally apply. The questions that we would get similar to that would be, okay, I'm a police officer, the police department's buying new vehicles to the fleet, and we're trading in some of the old ones. I want to go to the car dealer and buy the vehicle that's just been traded in. Can I do that? Generally, no. Because it has to be made available to everyone similarly situated, and it would be, you know, especially in these situations that we've dealt with over the years, it's been side deals that have been arranged, and that constitutes an improper use of public position. But issues, say the local gym is offering a discount to public safety people, 10%, 20%. We would say that's not allowed. If you want to offer discounts, it's got to be to a class of people, not the public safety folks, but if it's to town employees, all town employees, then it would be allowed. So it all depends on the nature of the discount, who the class of available people are, as to whether it would be allowed or not.
Okay. And the last one is, if an employee, public employee, is at a conference, and as is often the case, you'll have vendors at a trade show portion of a conference that have the fishbowl, and they encourage you to drop your business card in, and they're going to select a card, and you're going to win tickets to a Patriots game or something, clearly valued in excess of $50. How is something like that handled?
Well, that's, you're talking about conference swag, and we all love that stuff. That falls under the random drawings provision, as long as nothing is being offered to you by somebody who has matters before you that they're hoping you say yes to. You know, that you drop your business card in, and, you know, they're going to reach out. It would depend. I would say that with that type of a question, I would want our legal division to really look at that closely, because if all you're doing is dropping your business card in and then you're going to get something, you know, like event tickets, that could be problematic. But if you were to participate and vendors are offering things for anyone who attends to participate in, nothing's being targeted to you for your personal use, so it's going to be allowed. But if they're offering items, you know, where it depends on what kind of public position you occupy, and they're going to take this matter up after the conference, then it could be problematic. We'll contact you, we'll take you out to dinner to talk further about it. No, that's going to be a problem. Or put your business card in, and we're going to have a random drawing so that you have a chance to get these tickets to the Patriots game. That's a random drawing, that's going to be okay. but put your business card in and then afterwards we'll call you and give you a couple of tickets. That's not going to be okay because that's items offered to you personally for your personal use.
And the presumption would be that the random drawing is done publicly and at the time of the conference and not,
rigged games are not allowed, right?
Right.
In my example with the iPad, as a door prize, for example, if I put my business card in the fishbowl and the person offering the iPad also has a contract proposal that they would, like me to look favorably upon, and when they reach in to pick out the winner, it's my business card taped to their palm. Now that's a rigged game. That's not going to be allowed. So.
Gotcha. All right, those are the only questions that I saw come through. I don't see anything that's been added since.
And these are common questions. Gift issues in public town employees. You've got to understand that these situations can come up, and in most cases, you're not going to have time to plan. You're never going to see it coming. Out of the blue, the gift is provided, and then what do you do about it? We had a case one time where on the Steamship Authority, there was a limo company operator that wanted to make sure that whenever he showed up with the limousine that they got on the boats. And so at certain times, holiday times, what have you, he'd be providing holiday cards to the ramp employees who decide who gets on and where they get placed that had $50 in it, and the ramp employees didn't know what was coming. All of a sudden in their inboxes, here's a card with $50 in it. If you don't understand that the law applies and what the rules are, you could go a long way into getting yourself into some serious career-ending trouble. You want to just understand that gifts are restricted, and when in doubt, contact your supervisor for guidance, but call the commission. There may be workarounds, but then again, there may not be. So.
And I guess, David, one last question that does come to mind. You had indicated in your beginning of your presentation that there is the ability to call the commission and seek legal advice, and also to reach out, depending on what your local process is, to speak to town council.
Sure.
In what conditions or what situations is it required that you get a writing from council prior to the commission being able to respond? I recall something about that at one point along my travels.
It gets kind of tricky because the law says that that municipal council is authorized under Section 22 of the Conflict Law to give advice about the requirements of the law. The commission will be bound by that advice only if it has the opportunity to review and comment on the advice. Because if somebody gives advice and it doesn't comply with the law, we're not going to be bound by it, but we're going to notify council that we won't. Now, so generally there's some coordination. And usually when a town council is giving advice, they're on the phone with us to make sure that that the advice they're giving is accurate, and then they can provide the advice. The distinction between advice from town council and advice from the Ethics Commission is that the statute requires that advice from town council be made public. The opinion has to be filed with the town clerk. So town employees might be a little reluctant to go that route. Whereas when they contact the commission for advice, it's required by statute to be kept confidential permanently. Well, unless, if somebody gets advice from us and then they violate the conflict law, and the fact that they got advice is relevant to the violation, we can make that stuff public in connection with an enforcement action, but otherwise it's confidential permanently. The requester can release whatever they want. We're bound by the restriction.
Certainly. And then just a general comment, David, for those listening, my experience with the Ethics Commission has been that you are always willing to bend over backwards on the advisory side, the legal, lawyer of the day side, to keep us out of trouble. So I'd encourage everybody that's on the call here, if you have any question at all, talk to your supervisor. If not your supervisor, feel free to call the commission, because that's why that side of your house is there, to try to keep us away from the other side of your house.
Absolutely. That's a good point. Call us, as I said, it's a 5 or 10 minute phone call, or maybe it's a little bit more complicated, but if it is a little bit more complicated, you're going to want us to clarify the points for you. So don't be afraid to call us. Okay.
Excellent. Anybody final opportunities to either unmute yourself or send a chat for a question?
Okay, we do have one question that says, would you please share your contact info again? And I'll just If you have a pen, I'm going to tell you real quick rather than try to show my slide deck again and probably not get to where I need it to be. So again, it's David Giannotti. My direct phone line is 617-371-9505. And my email is easy enough. It's david.giannotti. That's Giannotti, 2 N's, 2 T's, at mass.gov. David Giannotti, david.giannotti at mass.gov. So reach out if you have any questions. I'll be happy to respond.
Excellent. David, thank you so much for your time today.
Okay, thank you, Jim, and Carolyn for organizing, and for all of you for giving me your kind attention. Okay, thank you very much.
Thank
Enjoy
you.
the rest of your day.
Bye-bye, folks.